Hi guys, it's AsandaNtini and welcome to my channel and welcome to today's video and welcome to the legal / graduate / I don't know corner where I share videos on my journey as a recent graduate. Though I graduated 3 years ago, but I'm still very new in the profession and I'm still awaiting admission, but it's coming very soon. Keep a lookout for that. And yeah, so what else do I want to say? Anyways, do not forget that none of my videos constitute as legal advice and also constitute as a substitution for any of the legal knowledge that you get from school. With that said, let's proceed with this video. So what are the different types of legal systems that are available, and do you know which legal system is used in South Africa, and also what are the trial systems used in the world and in South Africa? It's currently 10:15 at night. My bedtime is at 11:15, so we need to do this video very quickly because I want to avoid any more light on my face for the next 30 minutes before bed. Anyways, so I have introduced myself, AsandaNtini. Before we proceed with this video, don't forget to like, comment, and subscribe to this channel so that it grows more. And yeah, let us get into it. So why am I telling you about the legal systems? First of all, most students, which I believe most of my people that consume my content are law students that are just starting out, or people that are interested in studying law or getting into practice. People that are not in practice and people that are maybe going to first year mostly do not know the types of legal systems. And not next year, it's now next year. Schools are starting next month, I think. Anyways, so most of the time you are not aware of how do legal systems even work? How does it work? And you'd assume that, okay, everything works in Jengabu Harvey, where they just stand, shout at each other, and there's a jury, they stand in front of them trying to convince them. Is that how it works? Sometimes. Typical, it depends, answer, yabameli. Anyways, okay, there are the types of legal systems that I will share with you guys are 4. First one is common law. This is law that is created by precedent through which is mostly case law, where that case reasoning is followed in the next cases. For example, a case S versus Makwanyana. If you are going to be in first year this year, one of the cases that you will, by end of this year, I hope you will know, is the case of S versus Makwanyana. The reasoning behind why South African, what is happening here? The reasoning behind why South African law abolished death penalty. That's the case that you will read on, and that's one of the precedents that are followed. That's an example of a precedent. It's an old case, but its dicta is still followed until today. Yeah, okay, I'll also do, the next video that I'll do are different terms of law that are used so that you also understand before you get into school. And yeah, anyways, so yeah, common law uses legal precedent where most of the time they are interpreting statutory laws and statutory laws that are created by legislators. So that's what happens most of the time in common law. And then civil law is basically the statutory law that is created. So what common law would be interpreting is that, and it's mostly used in systems that are inquisitorial. I'll get to explaining what is inquisitorial and what is adversarial system when I explain the trial systems, because I think it's more relevant when you're explaining a particular trial system. And religious law. So different religions have different laws and rules that are followed in their religion, and these types of law are personal to different people. Most of the time they don't form part of the law of the general public, but rather laws that govern abantu that follow it. What are those? Some of the religious laws. It's canon law, which is what governs the Christian communities most of the time. Islamic, which is what governs the Muslim communities, and then Talmudic law, which applies to Jewish communities most of the time. And then there's customary law. Customary law is law that is found in the locals or tribal laws. Usually it's unwritten, but it's laws and customs that are followed by people that are local to that particular place. So in KwaZulu, we have laws that govern ukuthi KwaZulu, not AmaZulu do this and that. But Botswana people, where you mostly find people of Botswana, that's where you find the common customary law there, not common, but customary law that governs them. So they are tribe. So those laws differ by tribe and by local. That is why people are so confused when you tell them that you're not really married if ulojoliwe KwaZulu, because in as much as there's a different custom, I think it was Abapedi, the decision double HP, that confirmed before they were actually what we would refer as being married, was declared as a married, what we as Zulu people would declare as being married, is different than what a Tswana Bedi would declare as being customary marriage. So in a sense, each tribe, each custom, each local is different from another local. Those are the types of laws, and they are followed by people that stay in that particular region, that stay in that particular country. Whatever the custom is, it's different for each country, it's different for each region, it's different for each tribe. All right, and then, so what then is adversarial system and inquisitorial system? Those are two systems, and I'm going to explain them in a criminal trial process. An adversarial system is where a judge or a presiding officer, because it could be a magistrate in a criminal matter as well, is an impartial referee. And this person here plays an active role. Here they do not play an active role. The role players here are the prosecutors and the defense attorneys. They are both trying to prove a version yabo. Okay, this is my version, this is my version, and then the impartial referee, being the presiding officer, decides based on hearing the both sides. It's okay, this is what's true, or this is what I think is right. And the balance, or the proof, I'm forgetting the name, is different for civil and criminal law. In civil law, in order for you to win or have your case go to, like, I can't remember the term. In the video where I speak about terms, I will remember it. Here the test is balance of probabilities in civil matters. So if you are proving you have to prove that on balance of probabilities. The test is not as strict, not strict is not a right word, but the test is different than in criminal law. In criminal law, the test is beyond reasonable doubt. There should not be any doubt judge or the presiding officer, ukuthi you have proved your case. So those are the two, and in the adversarial system, they are there listening. And then also one thing to note, I've shared this before, in criminal cases, the witness is the complainant, the person who was affected by the crime. They are not the person that the accused is against. The accused is proving a case against or disproving the case of the state, and the witness is going to merely be there as a witness for the state. All right, and then the inquisitorial system is a system where judges play an active role in inquiring, investigating the facts. So the judges decide the law and the facts that are to be applied in that particular matter. They don't just sit and listen to sides and decide as an impartial person, but they have all the facts, they have all the information before them to decide. See, and then what's the role of juries in all of that? Each country is different. Most countries, well, I'm not going to say most countries. In South Africa, we do not use juries. We do, however, make use of assessors when it is necessary. There has to be a necessary, complicated or complex matter that is being before the court, that the presiding officer makes use of an assessor. And an assessor is somebody who is duly qualified and understands the matter and would have input kuma merits of when deciding the case. It's somebody who has an input in jury system. It's people that are, it doesn't have to be somebody who's qualified for that particular matter, and also they are just there to decide or to, they are there to decide on the facts to determine whether the accused is guilty or not. That's what happens. Okay, and then each country, most countries are not strictly inquisitorial, strictly adversarial. It depends on the merits of the facts, on the merits of the case, and what is to be proved. So could be both. The country could have a system of both or just one. What is the system in South Africa? So the legal system in South Africa is firstly hybrid. We have common law and civil law, and common law and civil law, as well as customary law. Mostly, the most important part about South Africa is that we are a constitutional state, meaning that the Constitution is supreme. The Constitution and the Bill of Rights are supreme, and all laws or actions must be consistent with the Constitution. Just know that it should be consistent with the Constitution. Remember that whatever you do. And then in our hybrid system, we have Roman Dutch civil law and English common law and customary law and religious personal law. Why do we have Roman Dutch law in South Africa? You might be asking, like, why? We have this because we have a history of colonial governance that is both English and Dutch. That is born in South Africa, and that influenced our law. But then, during their colonial times, they only applied AMA laws, AMA Dutch and the laws of Romans, and made it law of the country. So with the constitutional the democratic state and the constitutional supremacy, we then added a customary law into our laws. The Dutch law is seen mostly in our legal doctrines, and then while English common law is seen in our adversarial trials. The procedure that's used in English courts mostly is adversarial law, and that's the procedure that we use in South Africa. Did I mention that? Yes, but I don't think I did. But anyways, in South Africa, we use the adversarial system most of the time we use the adversarial system. When we are doing trials, the system is also used in reporting of cases, and our adherence to use of precedent can be also referenced to English law. So that's why we have the hybrids. That's how the hybrid system works. Then we also obviously have the common law, which plays a huge role in development of our laws. And right now, in the recent years, it's been mostly applied, and the precedents in common law and case law is being developed with customary law in mind, which is good. And we obviously also make use of international law and foreign law. And we are also part of the International Criminal Court. Are we still part of the ICC? I think we are. Please let me know below if we are still part of the ICC and if we are still part of the Geneva Convention. I didn't read on that. Are we? Okay, I hope. And Section 35 of the Constitution makes confirmation of the inquisitorial system, where an accused person showcases the inquisitorial system as well as the adversarial system, wherein with the inquisitorial system, judges can ask even witnesses or have access to all the cases. Yet with our constitution, especially Section 35, an accused person in the inquisitorial system that we have, where the accused is accused of a certain crime, they have a right to remain silent and also have a right to be presumed innocent until they are proven guilty. And they also have a right not to testify in trial. In a system like an inquisitorial system, I assume that you could be asked to testify, you could be testifying in a court. So again, in this type of system, in our system, in inquisitorial system, the judge remains a passive, the judge or the presiding officer remains a passive, remains to play this neutral and passive role of listening to all the sides and deciding who proved their case beyond reasonable doubt, or who proved their case on balance of probabilities. So yeah, we made it. It's 10:05. All right, guys, I hope this makes sense. And when you are getting into your first year, you understand more, you read more cases, but it's nice to come into class with a bit of understanding, which was one of the disadvantages that I think I had. I had to start from scratch because I didn't expose myself to legal content and expose myself to understanding the law before getting into law school, getting into university and studying law at first year. So yeah, I hope that you guys will find this video impactful, and I'll do another video which I'm really excited about. I do one video on legal, like, what do we call this? Legal corner, where I do anything legal, graduate content, whatever it is. I do one video a week where I share all of that. And these next few weeks, I'm going to be focused mostly on law content, because I graduated with an LLB many moons ago. I'm joking, 2019. And I have more knowledge of that and I want to share it.